next case is 23-3665 Pedro L. Colon versus Jeffrey M. Bird individually and on behalf of his minor child, GL. How much time would you like for rebuttal?
Your Honor, I'm going to try and save about 5 minutes.
Okay, thank you. And you may begin.
May it please the Court, I'm Peter Webster with Carlton Fields, and I am here on behalf of the appellant, Pedro Colon. We have 4 issues, as the Court is aware. I intend to address them in the order that they're presented in the briefing, understanding that we will almost certainly not get through all 4, and recognizing that we will submit any of the issues we don't get to today on the briefing. So the first issue is that the trial court erroneously denied the motion to disqualify Bird as trial counsel. That issue is controlled by the plain language of Rule 4-3.7a.
Counsel, if we were to reverse on that issue, do we have any of the other issues that survive, or do they go away as well?
We would certainly like you to address the second issue as well, the discovery issue. Issues 3 and 4 would go away.
Okay.
So on the first issue, the disqualification issue, the issue is controlled by the clear language of Rule 4-3.7a of the rules regulating the Florida bar. And that rule says that with 3 exceptions, none of which is applicable here, a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness on behalf of the client. Notwithstanding repeated objections and motions for mistrial, Bird was allowed to testify. In fact, he was the final witness for the plaintiffs. He was allowed to testify at length about contested matters central to the case, including GL's condition before and after the accident, and her injuries, and to matters related to the accident itself. He also testified several times incorrectly about legal matters, including that the medical bills were his obligation under the law, even though he was neither GL's natural nor adoptive father.
Mr. Webster, as I read the record, my understanding is that the trial court denied disqualification based entirely on a legal premise that Mr. Bird had the right to represent himself, and even as the parent or next friend of his minor daughter, that he also had that right. So he was essentially pro se in both capacities. I don't find a Florida appellate decision directly addressing this question, but there are several federal appellate decisions. And I'll just read an example from one, the 11th Circuit in Whitehurst v. Walmart. It's a 2008 case. The court said a non-lawyer parent has no right to represent a child in an action in the child's name. Is that the rule that you're asking us to state in an opinion reversing, that Mr. Bird may have been able to represent himself pro se and had the right to do that as the parent of a minor party, that right doesn't carry over into that capacity?
I don't think that's the only rule we would like you to set forth. Our first argument is that because of the factual situation here, Mr. Bird shouldn't have even been allowed to represent himself in this trial, because the 2 representations were inextricably connected. It's also pretty clear that this was a ploy to allow Mr. Bird to testify in a closing argument manner, and it's perfectly obvious if you read his direct testimony. He wasn't responding to questions. He was providing speeches in response to every question. But it's clear, bottom line here, no matter how you look at this, it's clear that the real party in interest in this case was GL. This case is really all about GL and her injuries. Mr. Bird, as a stepfather, in fact, had no legal claim for medical bills.
Counsel, I know you raised the fact that he couldn't represent as a parent, right, whether he was a parent or not, did you specifically raise below the stepfather issue, the fact that he's not a parent? I know I'm not saying you didn't raise, parents can't do this. Did you raise the fact that he's not a parent?
Numerous times, Your Honor, numerous times. We even filed a motion that argued because he was a step-parent, he lacked standing. And if you'd like, I can get you the cite for that. But we argued it at the conclusion of the evidence. The motion was filed at the conclusion of the evidence. We're not raising that as a separate issue on appeal, but it's pretty clear that he took every opportunity to use that legal misrepresentation while he was testifying.
Okay, but you conceding you've waived that issue on appeal?
We have waived that as a separate issue on appeal, yes, Your Honor.
What do you mean waived it as a separate issue?
Well, it's still relevant to this issue, to the extent his testimony about being responsible, his statement about the law was just not correct.
But the fact that he was acting as a parent, and irrespective of whether a parent can do that, challenging whether he's a parent, you've waived that issue?
Yes, yes. So it's perfectly clear that the real party in interest here was GL. This was all about GL. The special verdict form that was used asked only about damages for GL, and that was a verdict form submitted by Byrd. Didn't ask for any damages on behalf of Mr. Byrd. Now, appellees will get up and say, yeah, but the final judgment awards all the damages to Byrd. Well, we didn't draft the final judgment. The verdict form clearly did not refer to any damages for Mr. Byrd. The trial court repeatedly, in its initial instructions to the jury and in its closing instructions, referred to GL as the plaintiff. Everyone understood that GL was the real plaintiff in this case, and so under the clear language of Rule 4-3.7a, Mr. Byrd was unable to testify on contested matters on behalf of GL, and that's precisely what he did.
So, Mr. Webster, am I correct that you believe that because he was a witness, he should have been disqualified under the rule? But I take it you would not have any issue with Mr. Byrd's being trial counsel if he was not a witness?
Oh, absolutely not, Your Honor.
Let me ask you this. Suppose we reverse on this point, and Mr. Byrd elects to go forward as trial counsel and takes himself off of his witness list, could you force the issue by putting him on your witness list?
I think the law, in my recollection, is there's one of the cases the appellee cited, I think it's the In re Waltrop. It's a bankruptcy case in the Western District of Oklahoma. Seems to indicate that the law is the opposing party can't do that for obvious reasons. So I think the answer is no.
Really? I mean, so if there was some crucial witness in a case, you could remove them as a witness by hiring them as your attorney, assuming they're a licensed attorney?
I'm sorry.
Doesn't that mean in any case, if there was an attorney who happened to be a crucial witness that was bad for you, you don't want them to testify?
Well,
You could stop them from testifying just by hiring them as your trial counsel?
Your Honor, frankly, I've not researched all of the law on that issue. The case that came to mind was this Waltrip case. It says what it says about that issue. That's not our case. That's not this case. And I think I can safely represent to the court that if this matter did go back down for a new trial, we would not employ that tactic.
And let me stick with the rule. I noticed in your motion to disqualify, it included, I believe, striking 8 or 10 video depositions that Mr. Byrd had conducted. In asking us to reverse, are you asking us to also tell the trial court that all of those video depositions must be stricken?
If he was the lawyer conducting the examination, I think that's the logical conclusion, Your Honor. And let me explain to you why I think that's not unfair. Appellees take the position on appeal that we waive this by waiting too long to raise it. The cases they cite relate to attempting to disqualify counsel, opposing counsel, entirely from a case.
Based on conflict of interest.
Exactly. This is a completely different situation. And we represented, Your Honor's familiar with our motion, we represented in the motion that trial counsel had discussed this with Mr. Byrd at the outset of the case, and that Mr. Byrd said he was going to get counsel to try the case, and that the only reason this motion was being filed was because apparently he'd not done that.
Is there anything in the record that establishes in those representations, he said, I'm not going to use the depositions I did?
Well, to the extent he wants to use them at trial, he should have been aware he was going to have a problem under the rule. So Mr. Byrd, we represented in our motion that Mr. Byrd said that at the beginning of the case. On appeal, appellees say, yeah, but there's nothing in the record that supports that representation.
Well, the trial judge, by denying disqualification, essentially left you unable to litigate that particular point. So,
Well, and more importantly, Your Honor, Mr. Byrd has not denied that ever in the trial court or in this court.
I want to get back to the depositions, because as I understand the purpose behind the rule, at least reading the comment, is that the reason as a jury can be sort of misled or they might misunderstand a lawyer both answering questions to give evidence and commenting on that evidence as an advocate. Whereas in a deposition, the lawyer is just simply asking the questions. So I'm wondering is the deposition transcript, even if done by video by Mr. Byrd, does it really implicate the concerns of the rule like him answering questions on the witness stand would?
Well, Your Honor, we took that position in the trial court for purposes of this appeal. I'm prepared to say that we won't take issue with those depositions being used at a retrial.
Thank you.
Is there anything to the significance that Mr. Byrd had other trial counsel? Like if a party shows up with two lawyers that says, I also want to question witnesses and participate myself, are you pro se if you have lawyers? I don't think any of the cases dealing with whether a party can represent themselves pro se or whether a lawyer can represent themselves pro se, I didn't see any of them where the lawyer was also in fact represented by two other lawyers.
I've seen that in criminal cases from time to time, Your Honor. I've certainly never seen it in a civil case. To me, the significance, the fact that Byrd showed up at trial with other lawyers is it's a concession that Rule 4-3.7A4 is inapplicable. That's the one where it says you can go ahead and do this if disqualification would work a substantial hardship. There's no hardship here. They never argued hardship, but there's no hardship because they showed up at trial with lawyers, with other lawyers. And it just shows that, demonstrates, I think, that this was really all kind of a ploy to allow Mr. Byrd to put in all of these long, rambling perorations as a witness because, these lawyers could have handled the whole case. Or Mr. Byrd could have not testified and handled the whole case. He just chose not to do that.
Given that the trial judge made his ruling based on what he perceived to be Mr. Byrd's right to represent himself, if we were to reverse, would Mr. Byrd have the ability to litigate paragraph 4 on remand? In other words, could that still be brought up and sorted out by the trial judge, or are you asking us to say he just can't do it?
Well, 4-3.7A lists 3 exceptions. The first is, 2 of them relate to the nature of the evidence,
Right.
which clearly are inapplicable here.
Right.
And the third one is hardship. And they demonstrated there's no hardship because they had other lawyers present. So there's nothing to relitigate. This is a simple application of the rule to undisputed facts. That's why, as we argued in our briefing, the standard of review here is de novo. Because but even if it weren't, even if it were abuse of discretion, that discretion scope is cabined by the rule.
Counsel, I want to make sure I ask you about the discovery issue before you leave.
Thank you.
Because there wasn't a lot of talk in the briefs about just the language of the discovery rules. And I'm looking at 1.280, and it says in the subsection D for protective orders that when somebody files a protective order, the trial court can change the terms and conditions of the discovery. The court may order that the discovery may be had only on specified terms and conditions. Why couldn't this discovery procedure be terms and conditions ordered by a trial court?
Well, first of all, Your Honor, there was no motion for protective order under 280 here. This was an objection under 351.
I mean, it's in the subpoena rule too. I mean, it's in 1.410, the trial court may modify the subpoena.
But to answer your question, the reason is because you can't put the fox in charge of the hen house.
But that just seems like a policy argument as to why, like, I mean, this is a term and condition of discovery, is it not? You just say this is a bad idea, but
No, I didn't.
what I'm asking
well,
for you is why is it not in the scope of the language of the rule?
I mean, it is arguably within the scope of the rule, but the response to that is it's an abuse of discretion. See Rojas
So let me
versus
ask you,
Ryder
I think
Truck.
Rojas was different because in
It was
Rojas, the
different.
person was able to control the scope of the request, not just the response, you know, filtering the response. And the reason I'm skeptical of the argument that this is such a crazy procedure is because this is the procedure for all first-party discovery, which is most discovery and litigation. When you serve a discovery request on the other party, they have the documents themselves, and they and their lawyer are necessarily the gatekeeper. That is most discovery and litigation.
And that's precisely the procedure the court in Rojas condemned.
It's not though. In Rojas, the party was going to be able to go to the third party and request the documents, and so the party not seeking documents in the litigation would have control over the scope of the request, not just the response, right? Here, it was not going to change the scope of your subpoena. It was just who did the responsive documents go to?
But what the court said in Rojas is allowing a procedure similar to 350, a request for production, won't work here because it relies on the veracity of the responding party.
I guess I'm saying, why is that? All right, taking aside any differences in Rojas, even if you assume that rule is the clear rule of Rojas, why is that the case? Why can you rely on the veracity of the party for the vast majority of discovery and litigation, which is from that party, but it's super dangerous to do that for third-party discovery?
Well, for one thing, if the lawyer for the objecting party is the one deciding what documents to pull out before they get delivered, there's no way to ever know.
How is that different from when you serve a request on the other party? That's what their lawyer does.
Because then, if you're not happy with that, you can use 351 and go to the non-party and get those documents.
No, but I'm talking about for documents that the party themselves has, and maybe a non-party doesn't have, right? Most discovery and litigation is between the two parties, right? And for most of those, it's document that no third parties are involved in. And in those situations, the other party and their lawyer is the gatekeeper by necessity because they have the documents. And we rely on the rules of professional conduct for that, and the discovery rules and the prospect of sanctions for that discovery to occur. I mean, that's the vast majority of discovery is handled under the exact procedure you're saying was an abuse of discretion to order as to third-party
Okay,
discovery.
so in addition here, the gatekeeper was an adverse party in the litigation. That's one thing. And in addition to that, this court has already noted that criticisms regarding Mr. Byrd's professionalism are significant. And so there's no way for us to know whether we're getting a fair deal or not.
In first-party discovery, right, if the other party controls the documents, when you request documents from the other party, and they're an adverse party in that situation too, so that's not a distinction. And so is the argument, as to the second point, is the argument here that the trial judge should have kind of taken judicial notice of prior past conduct and said, as to this specific lawyer, this procedure is not permissible?
The principal argument here, Your Honor, is there is no way to ensure, other than relying on the good faith of the opposing lawyer, that we're going to get all the documents we're supposed to get. And as Judge Smith pointed out in his concurring opinion earlier in this court, because of that, you can't do that unless the two parties agree to it. It's just not an acceptable procedure.
All right, so counsel, that's my last question. So you have this fear that you're relying on the other party's veracity. How is that same fear not present when you have to get documents from the other party directly, documents that only they possess, which is most of discovery and litigation?
Because you have lots of other tools to double check to make sure you're actually getting all the documents from the opposing party.
What tools do you have in that circumstance that you don't have in the third party circumstance?
You have requests for admissions, you have depositions, you have.
You can take depositions of third parties, right?
Well, you can, but the whole purpose for 351 is to avoid having to do that just to get documents. So this procedure essentially defeats the whole purpose of 351. And Mr. Byrd, you saw from his objection, he does this in virtually every case. He gave you, there were at least 6 or 8 orders from other trial judges in the Ninth Judicial Circuit where he requested the same procedure. He does it in virtually every case.
Well, into your rebuttal time, we'll give you a couple minutes
Thank
for
you.
actual rebuttal. Thank you.
Very small food and a very big amount of stuff.
Good luck.
May it please the court, Megan P. Glucka on behalf of the appellees, Jeff Byrd. Would you like me to start in any specific place?
Well, given, we're going to use a lot of the time, maybe we'll just jump right into it. The disqualification issue, the trial court ruled that denied disqualification, cites the Baker case, essentially says that Mr. Byrd had the right to represent himself in both capacities, individually and as the parent or next friend of GG, or GL, excuse me. The right to represent oneself derives from the Florida Constitution's right to access to courts, and I find ancient authority sort of endorsing this practice of a parent acting as next friend for a minor child. But I don't find in any Florida case law is any authority that says that that right to represent oneself includes a right to represent, for a non-attorney parent to represent a minor child. And in the absence of that right, it seems like the minor child can only be represented in court by a lawyer. And if that's true, then 4-3.7 must apply. Is my analysis wrong somewhere?
So, Your Honor, Rule 17 is a federal rule. It has a rough equivalent in Florida State Court, but if you look at that 11th Circuit case, the reason that they said that that parent couldn't represent is because Rule 17 lists 4 people who can represent a child: a committee, a conservator, a like fiduciary, or a general guardian. So in this case, Mr. Byrd was acting for himself. And by the way, I want to clarify something that Mr. Webster said. The defense's motion to disqualify at paragraph 3 says plaintiff Jeffrey Byrd is claiming his own damages. So there is no question that Mr. Byrd was claiming damages for himself. The defense acknowledged it in their motion, and the business about the verdict form, it's so that the verdict form didn't say what are the past expenses, or what are the medical expenses for Gigi Luhia's future care that go to Jeff Bird until she reaches the age of 18, and then after the age of 18, when she becomes an adult, what future care, like that would have made the verdict form silly, which is why it didn't say it that way, but there's no question that he was seeking his own damages. I want to put that to bed. And second, Mr. Bird was acting as, excuse me, he was acting as the guardian for his minor child, number one, and number two, he is a lawyer. So he can represent her.
Well, but I think that's the issue. There's no question that Mr. Bird could represent his minor child in litigation as a member of the Florida Bar. He's authorized to practice law. But that really gets to the heart of the question, because if the trial judge said basically 4-3.7 doesn't apply here because he's representing himself, he's self-represented, that's a right that he has. But I don't find that right in any Florida authority. In fact, 1937, there's a case, it is Garner v. Schilling, and it assumes that just because a next friend, it uses this old French term, prochain ami, just because a next friend can bring a lawsuit on behalf of a minor, that doesn't mean that that next friend is authorized to represent the minor in court proceedings. That still requires a member of the bar. Now here, I don't think the issue is whether Mr. Bird could represent his minor daughter as an attorney, but as an attorney, he's then subject to all of the rules, including 4-3.7. I don't see how the trial court could get around that by saying, well, he's got a right to represent himself.
So, Your Honor, there is no Florida court case that is directly on point. No Florida court case has analyzed it. However, the answer brief pointed to a plethora of out-of-state cases that have analyzed it. And the out-of-state cases, their rules are, if not verbatim duplicates of Florida's, they are extraordinarily close because they're all based on the ABA's model rules.
Well, as
And-
I read the answer brief, that's only dealing with cases talking about an attorney's ability to represent his or herself. But you've only put in a footnote the issue of whether that attorney can represent a minor child and whether the rule doesn't apply in that situation. So I don't think that this issue has really been addressed by any of the cases you cite in your brief.
Well, Your Honor, I guess my hang-up is that there's no question that Jeff Bird is an attorney, and there is no question that Jeff Bird could represent his minor child because he is acting as her guardian. There is no,
Well,
so
I
in other
don't
words.
think that's not a represent. When the lawsuit is filed by a parent as guardian or as next friend of a minor child, that's a standing convention. I mean, there's no doubt the lawyer has the right to bring that lawsuit, or a parent has a right to bring that lawsuit in the child's name. It's a separate question whether that parent can also represent the child in court, which usually requires a member of the Florida Bar. And the case law says, well, you can represent yourself, both criminally and in civil cases, not being a member of the bar. That's a constitutional right in Florida. But there's no constitutional right for a non-lawyer to represent a child. And that means that every time Mr. Bird appeared in court on behalf of GL, he was appearing as a lawyer, which means all of the rules applicable to lawyers must apply. And as I read 4-3.7, he can't be both the trial counsel and a witness. I don't see any way around that, just by saying, well, he had a right to represent himself.
Well, Your Honor, the first argument that I would make in response to that, because I think I understand where you're going now, is that the defendant never raised that argument. So it's not an argument that this court should consider because it was never raised and it wasn't properly developed below. And the trial court wasn't given the opportunity to consider that argument. And this court, as longstanding Florida law says, doesn't consider issues that were not raised below. That's the first point that I would make. And the second point that I would make is that the case law that is cited in the answer brief goes to the purpose of the rule, because disqualification is an immensely unusual remedy that should be used sparingly. The law in Florida is very clear about that point. And the cases that we gave you said that the purpose behind the disqualification rule is to prevent situation in which others might think the lawyer, as witness, is distorting the truth for his client, or is enhancing his own credibility as an advocate by virtue of having taken an oath as witness as well as the uneasy situation that arises when opposing counsel must impeach on cross-examination another lawyer adversary. And the 10th Circuit Court of Appeals has said to apply that rule when the testifying advocate is a litigant in the action miscomprehends the thrust of the rule. The equivalent of 4-3.7 regulates lawyers who would serve as counsel and a witness for a party litigant.
In this case, that would be GL. GL is the party litigant,
Correct, and
and Mr. Byrd was serving both as counsel and as a witness for GL.
correct. And my point is that these arguments, so the court says that that rule does not address the situation in which the lawyer is a party litigant, and any perception by the public or determination by a jury that a lawyer litigant has twisted the truth surely would be due to his role as a litigant and not, we hope, as his occupation as a lawyer. A party litigant, moreover, as a party litigant, a lawyer could represent himself if he so choose. We can see no reason why the right to self-representation should be curtailed, especially in light of the non-existent concerns over credibility and impeachability, prejudicing a third party. Because in that circumstance, when Mr. Byrd is on the stand and Mr. Byrd is standing at the podium, and by the way, we've cited to the record, he was very careful to tell the jury, I'm playing two different roles here, and when I'm standing here behind the podium, what I say is not evidence. It's only when I take the stand that what I say is evidence. And I would also point out that during the entire trial, 1,972 pages, I believe, of transcript, the defense can only point to 2 places where the defense counsel was bothered enough to even object. He didn't ask for a curative, and he didn't ask for a mistrial. So if there was an error, you also have to find that it was harmful. And here, Mr. Byrd went out of his way to make the statement that I am playing 2 different roles. And the jury could see that. And that is what all of these cases that we cited to you, Ohio, the 11th Circuit of Appeals, the 8th Circuit, the 10th Circuit, Pennsylvania, Virginia, they all say the same thing, which is lawyers or juries aren't stupid. They can see that when the lawyer is standing up there and he's representing himself and his daughter, and it's clear that he is her father and he's testifying on the stand by that, they know what's going on. And if they think he's warping the truth, then they're going to think that because he is acting as a father and an advocate and not because it's a disinterested client.
If that's true, why does the rule speak in mandatory terms, shall not be trial counsel and a witness, and doesn't say, but you can fix it with a curative instruction to the jury? In other words, the rule doesn't contemplate that this problem can be solved simply by telling the jury, keep in mind that he's wearing 2 hats here.
Well, Your Honor, I would say that that would be at odds with the absolutely unequivocal uniform case law of this state, that disqualification is an immensely unusual remedy and that it should be used sparingly. I would also point out, as we did in the brief, that the defense didn't take the opportunity to take this up on certiorari. If they were actually concerned about it, why did they not do that? And there is precedent for the idea that if you wait to take a plenary appeal on an issue like this, that they're now arguing is so incredibly fundamental, that this court should look on it with suspicion. And I also would note that Mr. Webster told you that the standard of review here is de novo. That is dead wrong. The reply brief cites a Florida Supreme Court case, Young v. Achenbach, 136 Southern 3rd 575. The reply brief cites that case for the idea that the standard of review is de novo. It perplexes me because the Florida Supreme Court said at pages 580 to 81, in this case, the 3rd District's review should have been limited to whether the trial court abused its discretion in granting the disqualification motion. And then they quote from the 4th DCA, the standard of review for orders entered on motions to disqualify counsel is that of an abuse of discretion. So here you would have to find that the trial court abused its discretion and that there was harm.
But don't we also have to look at any underlying legal standards and decide those de novo on the way to deciding whether there was an abuse of discretion?
Well,
And the
Your
trial
Honor,
court can't make a legal error and say, I have discretion to do that.
the trial court's discretion is limited by the applicable legal principles. However, those principles are based on policy considerations. So again, disqualification is an extreme remedy, and the policy considerations behind the lawyer-witness rule is that if I am representing a corporation and then I go take the stand on behalf of that corporation, the jury could be potentially confused. It could be
Counsel,
unclear to them.
The Supreme Court may take into account policy when it decides to write rules. Once the rules are written, we're not the writer of the rules, and we don't consider we're not policy judgments on that in that place. For us, we just have this word that says shall, and whatever policy judgments, the writer of those words may have taken into account led them to use certain words. And I agree with you, the disqualification is a rare remedy, but this is one of the places where the rules say shall. Whatever policy judgments they made, they then use that policy judgment to give lower courts an instruction of shall, didn't they?
Your Honor, it is first of all, I see this all of the time. It is courts that are terrified to move beyond a strict construction. And it does say shall, Your Honor, the rule does. However, there is a body of law. There is no case law in Florida, number one, and the only case law that was cited by the defense is the Springtree case. And even in that case, the fourth DCA didn't say that the lawyer who was representing himself and his wife did violate 4-3.7. The court said that it could. The only reason that they disqualified there is because they said the word, it was obvious. It was obvious that that lawyer could not sue Springtree, the shopping center, because that was his law firm's former
I
client.
actually agree with you about the strict construction concept. I don't know that that's a very useful concept in a lot of cases, but you don't have to very strictly construe the word shall and take it as mandatory, right? That's kind of obvious and plain meaning. Strictly, I mean, that's just obviously mandatory language, is it not?
Well, Your Honor,
Like, that's not really ambiguous language that we're strictly construing. Shall is kind of shall.
well, again, I go back to, you look at the shall in the context of when that rule is, the circumstances under which the rule is being applied, because there is an as-applied challenge here, which is,
But it gives certain circumstances where it carves out from the shall, doesn't it? I mean, it says shall except 1, 2, 3, not shall except when it otherwise makes sense.
Your Honor, all I can say to you is that we cited to you a wealth of out-of-state cases that have decided the issue, and the wealth of out-of-state cases say that under circumstances like this, that it's not a disinterested lawyer who is testifying on behalf of their corporate client where a jury could be confused. This is a man who's bringing his own claims and bringing claims on behalf of his child. It is painfully obvious to the jury that if he was going to twist the truth, because that's the purpose behind the rule, if he's going to twist the truth, he's going to twist it for his own reasons, and the jury can see that, and it shouldn't apply. And finally, because my time is dwindling, I do want to bring up the timing here. Your Honors, the defense put Jeff Bird on their own witness list on November 4th, 2002.
I totally get your point about the delay, and they say that this was just a disqualification for trial and not for the whole litigation.
Their motion does not say that.
I guess if you assume that's true, right, I'll just ask you to assume first this question. How far in advance, because I think it's an interesting question, right? Because even if it's just for trial, if you do it the night before trial, I think you've delayed, right? If you do it 8 months before trial, less so. Assuming you're just trying to disqualify a lawyer just for trial, how far in advance do you need to do it?
Well, the law says that you look for reasonable promptness. Reasonable obviously has room. It's going to be a discretionary call. However, in this case, in their own motion, they listed the 9 depositions that Jeff Bird had taken. Obviously, Jeff Bird took them. When the complaint was filed in October 2001, Jeff Bird's name was the only one on the case style.
They represent in the motion as well, though, that there was a representation by Mr. Bird that he wouldn't act as trial counsel, which seems like that would forgive them not saying anything while he was taking depositions or even up to 45 days before trial. By just simply denying the motion, I don't think the trial court gave the parties a chance to litigate that representation to decide whether it was made or not. Doesn't that matter here?
Your Honor, I think what matters a little bit more is the procedural history, and here's why. They waited until after their motion to continue had been denied. And then they waited until after their case didn't settle at mediation. And then they waited until after their expert was stricken. And then they waited until after that motion to disqualify the expert was stricken. And at that point in time, under the rules that were in place, if you could get your trial continued, you would have more time, which meant more time to find another expert. And so, Your Honor, I think it's very important to look at the procedural history, because if Mr. Byrd had been disqualified, then that meant this case wouldn't have gone to trial in 45 days. It would have been continued again. It was, I heard Mr. Webster use the word ploy several times, and while I don't like to go there, I think that the procedural history is important and the waiting is important, because it was very obvious that Mr. Byrd was going to be a witness, and what they said was a very vague, we've talked to him before. And Your Honors, if you're going to file a motion 45 days before, then you say, I talked to Jeff Byrd 6 months ago about this, or I talked to Jeff Byrd 3 months ago about this, or whatever it was. But the point is that on November 4th, 2022, they knew if it was important to them.
Did you say anything in your response of, hey, that conversation just happened 2 weeks ago? I mean, was there any contesting of their position that they had reason to believe Mr. Byrd was going to get separate trial counsel?
Your Honor, I do not think that anybody developed that in the record at all.
I mean, I take your point about the specificity, but they made the point, and you didn't contest it, did you?
I do not have the record memorized. I had more time. I've only got 58 seconds. I could look and tell you, but
Yes, when a parent hires a lawyer, say, assume a non-attorney parent of a minor, minor has a lawsuit to bring, they're in a car wreck, whatever, and the parent, as the parent hires a lawyer, okay, and the parent is acting for the child and managing the litigation, the lawyer is representing. Is the lawyer representing the parent in that situation or the child?
are you talking about an instance like if,
And just generally, so, child is injured, whatever, has a reason to sue someone, and obviously, a 6-year-old can't sue. Their parents bring the suit in their name, like you're saying happened here. And I'm just saying, take it, it's a non-attorney parent, and they go hire a lawyer. And the lawyer brings that lawsuit that the child has, but that the parent is bringing on their behalf. Is the lawyer's client in that circumstance the parent or the child?
it would depend on what the claims were. If the parent was trying to recover what the parent had paid for the child's medical bills, then the lawyer would be representing both the parent, because a 6-year-old isn't legally responsible for their medical bills, and the child for the child's non-economic
But as
damages.
to the child, I take your point, it could be both, and the lawyer could have 2 clients. But as to the child's pain and suffering, is the lawyer representing the parent or the child? Who's the client?
In a legal context, it has to be the parent, because Rule 17 in the federal rules and Rule 1.210 in the state rules say that a child can't represent themselves, they have to be represented by someone else. So similar to a wrongful death situation, the attorney represents the estate. There are members of the estate, but the attorney represents the state and the estate. And here, if a lawyer was hired to represent a parent who wanted to bring a lawsuit on behalf of their child, and that parent also wanted to recover the money that they had paid for the medical bills,
That's a
the
good
parent
example,
would
though.
be,
The personal representative in that situation directs the attorney, because the personal representative acts on behalf of the estate, but the lawyer's client is the estate, right? That's the real party in interest?
well, the personal representative is the client.
Yeah, as a personal representative of the estate.
Well, in this case, though, to Judge Ganem's point, the child cannot represent themselves. The child has to be represented by a guardian, and the client is the guardian. The child isn't telling the lawyer what to do. The guardian is the one who's
Yeah,
making
the
the
guardian's
decisions.
doing that for the child. I guess I'm just saying, is that because the guardian is the client, or because the child is the client and the guardian is acting as on their behalf as guardian in directing their attorney?
The guardian, Judge Ganem, it's all clicked together for me. I think in response to your question, under the law in Florida, Gigi Lahia could not have represented herself. She needed Jeff Bird to bring that lawsuit. Jeff Bird represented himself for his own damages for what he paid for her medical bills, and Jeff Bird represented himself because he was acting as her guardian. We don't let 12-year-olds decide what they're doing.
So that's based on the idea that when a parent hires an attorney for the child to bring claims on behalf of the child, in order for your argument to work, the client in that situation must be the parent/guardian, not the child.
Correct, the client is the guardian. And
If a parent is acting for a child, say that same situation, but the parent's a non-attorney, parent doesn't want to hire an attorney, can a parent, assume there's just claims only on behalf of the child, right? There's nothing but the child has claims, pain and suffering, that's it. It's only the child's claims, parent has no claims. But the parent is the guardian of the child, and the child needs to bring the suit. Can the parent represent the child in court?
can the parent represent themselves? Because again, it
Yeah,
is a legal, it's
I'm not
the
trying to,
legal
I'm not trying
setup
to get,
that
I'm not trying to
we,
get bogged down in the semantics. Can that parent walk into court and pursue that child's claims without an attorney?
a parent acting as a guardian on behalf of their child to bring a legal claim could proceed pro se in Florida state court because they're acting, their legal capacity is as the guardian for the child, because we don't allow 12-year-olds to bring lawsuits. We don't allow 12-year-olds to tell lawyers what to do. So I believe that Mr. Bird was acting pro se for his own claims and for the claims because Gigi Lahia could not bring that lawsuit. He was acting as her guardian. And if the only claims that Gigi Lahia had were non-economic and he wanted to go hire a lawyer, Jeff Bird wanted to go hire a friend to represent him in that case, they would be representing him. They would be representing Jeff Bird as guardian for Gigi Lahia. And I know that I'm over my time, but could I just indulge me for 30 seconds regarding the records?
30 seconds.
Thank you. So it's an abuse of discretion to standard. Everyone agrees. And the record has 42 pages of other orders because in that circuit, it is common practice, and those orders are at 144 to 186. It is common practice for judges to do this procedure. One of the orders that he included, this same judge issued this same procedure against the same defense lawyer. That defense lawyer took it up on cert to the 5th DCA. I handled the appeal, and the 5th DCA denied cert. So this trial judge knew that this procedure had not
Denial
been...
of cert's discretionary by an appellate court though, right?
Correct, Your Honor, but my point is, how is a trial judge supposed to believe that he would be abusing his discretion? Because Canacaris v. Canacaris, the Florida Supreme Court says that an abuse of discretion can only be found...
Counsel, isn't the more on-point argument that the rules say trial judges can modify the terms of discovery?
Yes, Your Honor, and I mean, even the
Okay, you're well
Rojas...
past your time. Can you please wrap up?
Yes, even the Rojas case, the Florida Supreme Court says that, to your point, Judge Mize, the rules governing discovery are not exhaustive and do not prohibit judges from using their discretion to fashion an appropriate remedy.
Thank you, counsel. It's saying 213 on it, so we will go with that. Charlie, did I mess this up? Okay, so we're gonna go with you having 2 minutes and 13 seconds.
We probably will let you stop in a minute, so.
I'm happy to stay as long as you want me to.
Oh, this was 2 minutes and 15 minutes over, so, okay, so we'll give you until it says 5 minutes.
I want to first correct some misstatements that I'm sure were inadvertent by opposing counsel. The motion that was filed was titled Defendant's Motion to Disqualify Plaintiff Jeffrey Bird as Trial Counsel for Plaintiff Giselle Elijah. Secondly, in that motion, it says defense counsel has conferred with plaintiff's counsel about this subject long ago, and plaintiff's counsel represented that he would find another lawyer to try the case, but plaintiff Bird has not done so to our knowledge, therefore this motion is filed. They have never attempted to refute that. Second, with regard to certiorari, we heard that both with regard to the discovery motion and with regard to the disqualification. Certiorari wouldn't be available in either situation because there's no irreparable injury. What happened in the prior case, in the 5th DCA, that counsel represented she handled, it wasn't denied, it was dismissed. And I suggest to you the likely reason was because there was no irreparable injury that couldn't be remedied on appeal pending entry of a final judgment. The same would have been true here if we'd have tried to take a cert petition from the order denying the motion to disqualify Mr. Byrd as trial counsel. Third, counsel referred to a wealth of out-of-state cases cited in her brief. In fact, there are 3 cases cited. Brooks, Angino, and Waldrop. 2 are trial court cases, and the third is a South Carolina case where the court actually held that the lawyer's wife could not represent him because of Rule 4-3.7a. Those are the only cases they cite. That's the wealth of cases. With regard to, let me just go finally, with regard to Rule 4-3.7a, it could not, Your Honors, be clearer. It says a lawyer shall not act as a lawyer if he is to offer material conflicted evidence at trial unless, and then it lists 3.
Counsel, can I ask you to address before you go the
Sure.
questions that I asked your opposing counsel? When a parent hires a lawyer to represent their child has claims, child can't bring their own lawsuit, parent's not an attorney, parent hires a lawyer to bring the child's claims. Is the attorney's client the parent or the child?
I would say arguably both, but the real party in interest is the child. You can't read this transcript and conclude anything but that the only real party in interest in this case was the child. Mr. Byrd's verdict form doesn't even ask for a damage award on his behalf. Thank you, Your Honors.
Thank you. Thank you. We will be in recess.